Good evening, everyone, and welcome to a public conversation about our Constitution with David Boies and Ted Olson, two of the most distinguished and well-known litigators in America today, along with NHPR's Laura Knoy, host of the popular Exchange program. Good evening to you all. My name is Sherry Young, and I'm president of the New Hampshire Supreme Court Society, one of the hosts of tonight's event. Tonight is the final significant public event of Constitutionally Speaking, which is a partnership project of the New Hampshire Supreme Court Society, the New Hampshire Humanities Council, and the University of New Hampshire School of Law. A year-long project, Constitutionally Speaking, aims to promote meaningful civics education in New Hampshire schools and spirited dialogue about the nation's founding document among the state's citizens. We're focusing on two major initiatives. The first is to reform civics education in New Hampshire's public schools so that by the time students graduate from high school, they will have gained the basic knowledge, experience, and inspiration to engage meaningfully in the civic lives of the communities. Good civics education must reach those students who will not go on to college, as well as those who will. And it must be taught from kindergarten through high school. Our second goal is to encourage spirited but civil discourse and dialogue among people of all ages about the issues of our time. This is what tonight is all about. Which brings me to this impressive audience. Joining us in the audience tonight are public school students and their parents, teachers, and school superintendents, law school students and their professors, constitutional scholars that have presented on these issues, members of the state and federal judiciary, civic leaders and engaged community members, and friends of yours from near and far. The response to this program has been overwhelmingly positive. We have a capacity crowd of about 1,300, and we had a waiting list for those who could not get tickets. The program is being recorded and will be available to all New Hampshire public schools. The video of tonight's program, as well as still photographs and other materials, will also be on the Constitutionally Speaking website, which is identified in your program. Before we get into the program, kindly turn off all electronic devices and please, no photographs. Sorry.
No more.
No more photographs. It is now my great pleasure and privilege to introduce our special guests. Renowned litigators David Boies and Ted Olson, together with our very own NHPR host of the Exchange, Laura Knoy, as moderator of tonight's discussion. Attorney Boies was once described by the Washington Monthly as, quote, a brilliant lawyer, a latter-day Clarence Darrow, and, quote, a mad genius, close quote, for his work on the United States versus Microsoft famous antitrust case, where he represented the Justice Department. He is more recently a founder and chairman of the national law firm known as Boies, Schiller, and Flexner, described by the Wall Street Journal as a litigation powerhouse, involved in many of the national trial issues of the day. You may also remember that following the 2000 US presidential elections, David Boies represented Vice President Al Gore in the Supreme Court case Bush versus Gore, which effectively ended the recount of the contested 2000 presidential election. Attorney Ted Olson is a senior partner in the DC office of the prestigious national law firm Gibson, Dunn, and Crutcher. From 1981 to 84, he served as an assistant attorney general, Office of Legal Counsel in the Reagan administration. For those of you like me who are old enough to remember, Mr. Olson was also legal counsel to President Reagan during the Iran-Contra affairs investigation. He successfully represented presidential candidate George W. Bush in the Supreme Court case Bush versus Gore, squaring off against none other than David Boies. Thereafter, Mr. Olson served as U.S. Solicitor General under President George W. Bush for several years. Apparently, the two do not hold a grudge over the matchup between them in Bush versus Gore, because the two of them subsequently joined forces and appeared together before the U.S. Supreme Court this spring to argue in favor of same-sex marriage in the landmark case Hollingsworth v. Perry. The two...
They like that better than Bush versus Gore.
I liked it better than Bush versus Gore.
The two of them have both been listed by Time magazine as being among the 100 most influential people in the world. Pretty cool. And now may I introduce our fearless moderator, Laura Knoy, host of The Exchange on NHPR. Laura is well known throughout New Hampshire for her in-depth coverage of important issues and is widely regarded for her interviews with presidential hopefuls. Prior to returning to New Hampshire to host The Exchange, Laura worked in Washington, D.C. as a newscaster for the public radio station WAMU. Before her career in public radio, Laura was a researcher for USA Today's Money section and a research assistant at the Institute for International Economics. Laura occasionally guest hosts national programs such as the Diane Rehm Show and Here and Now. Laura was named New Hampshire Broadcaster of the Year in 2007. Let's have a round of applause for our special guests. Tonight's program is an unrehearsed discussion. How does the Constitution keep up with the times? Please let the dialogue begin. Laura?
Thank you. Thank you, Sherry. Thank you for that wonderful introduction. And thank you to our guests for being here. It's wonderful to see you. Thank you for having me. I want to thank the organizers of this event. It is great, great, great to be here and wonderful to spend some time with the two of you gentlemen. Sherry mentioned that the theme is how the Constitution keeps up with the times. That definitely came up in the case that both of you argued before the U.S. Supreme Court. And Mr. Olson, I want to start with you. This question really was directly posed to you by Justice Scalia, who famously said, when did it become unconstitutional to exclude homosexual couples from marriage? And that got a lot of play on the news, as you know. But let's look at the question inherent in that. What is the constitutional basis, in your opinion, for gay marriage?
Well, David and I set out to prove, and we've talked about this a lot, and I apologize that the way this is set up, I'm sort of turning my back on some of our guests here, but we set out to prove that gay and lesbian citizens are like everyone else in this country. They're entitled to pursuit of life, liberty, and happiness. Marriage is a fundamental right, described by the Supreme Court 14 times as fundamental to our existence, to a part of freedom of association, liberty, spirituality. It is a building block of our society. We respect people who wish to get married, to love one another. When California and other states have denied the right of gay and lesbian citizens to get married, they've denied that fundamental right of happiness. Individuals whose sexual orientation would not put them in a happy relationship with a person of the opposite sex. It does no harm to heterosexual couples or the institution of marriage or the raising of children to allow gay and lesbian citizens to get married. And it's a discrimination against them because of who they are. And I could go on a lot because we spent so much time on this and we feel so passionate about it. I really like speaking about it because it's important. The more we speak out, the more people discuss this issue, the more people that recognize that this is not right in our country to deny our gay and lesbian brothers and sisters the right to that same happiness. They want to be respected. They want their relationships to be treated equally. And when a state like California puts it in the Constitution that individual relationships between gay and lesbian citizens aren't as well respected, that's the state of California saying you can discriminate. These people are different, and it brings about all kinds of discrimination against gay and lesbian citizens because we're telling young people, well, their relationships, something's wrong with them. They're different, they're unusual, they're to be less respected. So the great damage is done, and it's just plain wrong under our Constitution to put these citizens in a separate category and deny them equality.
Is it a 14th Amendment then, equal protection?
Yes.
Is that the basis
Yes,
of the argument?
the 14th Amendment to our Constitution guarantees everyone the right to due process, which means you have a right to fundamental rights in this country, and the right to equal protection under the laws. That's the right to protection of equal laws. And we were making the argument under both the due process clause that marriage is a fundamental right that can't be taken away, and marriage is a right that can't be taken away because of who you are. That's the violation of the Equal Protection Clause.
Yeah, what did you think, Mr. Boies, when Mr. Olson got that question from Justice Scalia? Since when did it become unconstitutional to not allow gay marriage? What went through your mind?
Well, I thought his response was the right response, which is really a rhetorical question. When did it become unconstitutional to prohibit people of different races from getting married? When did it become unconstitutional to segregate schools? Because what you have is you have a development of the law in which we, as Justice Kennedy has said so eloquently, each generation discovers that some of the things that we thought were sensible and right really serve only to harm and discriminate. And I think that when you see the progress of that law, what you see is the country coming closer and closer to what the fundamental ideals were of our founding fathers, because they were all fathers in those days. And when they talked about life, liberty, and the pursuit of happiness, when they talked about equal rights, when the Constitution begins, we the people of the United States. In those days, we the people were essentially white male property owners. And what's happened is, over time, who the we is in we the people has gradually expanded until, as Ted was saying, really the last official bastion of discrimination is the discrimination that our government practices against people based on their sexual orientation. We've got a lot of discrimination in our society, but this is an area, unlike other areas, where the government still discriminates against its own citizens. And I think it's important to keep in mind that the right to marriage equality is not a new right. Nobody is creating a new right out of the Constitution. The constitutional right to marry the person that you love has been recognized over and over again by the Supreme Court. The state of Wisconsin passed a law that said if you've abused one marriage, you don't get a second marriage license. If you aren't paying your child support or you abuse your spouse, you can't get a marriage license a second time. Supreme Court said, that's rational, that's sensible, but you can't do it. And the reason you can't do it is because marriage is such a fundamental right that you can't deprive people of that, even when they have engaged in that kind of conduct. And compare that to gay and lesbian couples who have only behaved in a normal way, only want to be with the person that they love. How could you possibly deprive them of the right that the Supreme Court says constitutionally is given to everybody else, even people who have abused that right in the past?
You mentioned Wisconsin. That actually raises another constitutional question. Since we're looking at this in with the overall framework of the Constitution, Mr. Olson talked about the 14th Amendment, equal protection. Is there a 10th Amendment states' rights issue here? What do you think, Mr. Boies?
Well, there are certainly 10th Amendment states' rights, but the 14th Amendment was designed to say there are certain rights that states don't have. The whole purpose of the 13th, 14th, and 15th Amendments was to say there are certain states' rights that we're going to take away. We're going to take away a state's right to discriminate against its citizens. We're going to take away the right of a state to deprive its citizens of due process of law, because we think fundamentally in one nation indivisible, there are certain rights that are so fundamental that everybody gets to enjoy them, no matter whether you live in New Hampshire or Texas or California or someplace in between. And there are certain rights that can't be taken away from you by any majority. Not a 52% majority like Proposition 8 had, not a 98% majority. Because there are certain rights that everyone has that are so fundamental that they are guaranteed to everyone, whether or not the majority at a particular time agrees with it.
I'd love your thoughts on this too, Mr. Olson, this idea that the 14th guarantees certain rights to everyone no matter where they live. Marriage has always been a states amendment, a states' rights issue, so you've kind of got the 10th and the 14th working at cross purposes here.
No, I
Correct
don't
me if
think
I'm
so.
wrong.
I don't think so. The 10th Amendment, for those who haven't spent their time reading the 10th Amendment, the 9th and 10th and 11th and 12th Amendment don't get much attention, even in law school. The 10th Amendment a little bit more. The 10th Amendment reserves to the states the rights that are not otherwise taken away and given to the federal government and supplied by the federal government, or reserved to the people in the Bill of Rights, the right to free speech and that sort of thing. So it's a reservation of rights to the states that are to the states of rights that are not otherwise described in the Constitution in one way or another. And the states have always claimed when there's been resistance to civil rights. If those of you who are old enough to remember the 50s and 60s when we were having battles over discrimination, David, by the way, was in Mississippi fighting for those rights. People who wanted to keep discrimination on the basis of a race, we're talking about states' rights. And we were talking about states' rights at the time of the Civil War, the rights of states to have slaves, to allow their citizens to have slaves. The 14th Amendment specifically says that all citizens, no state may deprive any person of due process of the law or the protection of equal laws or the equal protection of the laws. So the 14th Amendment is an explicit override, so to speak, of the 10th Amendment. Some arguments are being made about states get to do this sort of thing and that sort of thing. But no, and as David puts it, the reason we have an independent, aggressive judiciary to protect those rights because we don't put certain things up to a vote, and states just cannot do that sort of thing. The Supreme Court dealt with this issue when, in 1967, the state of Virginia, my home state now, I grew up in California, but I live in Virginia now, Virginia and 15 or 16 other states prohibited interracial marriages. And the Supreme Court unanimously struck down the provision in the Virginia's laws that made it a felony if you were to marry someone of a different race. The president, when he was born, if his parents had tried to get married in Virginia, they would have been committing a felony under this kind of law. So the Supreme Court brushed that away and says, no, it's not a matter of states' rights. It's a matter of fundamental Constitution, individual rights. The other thing, one of our opponents during the course of the Proposition 8 case talked about, well, states have the right to restrict marriage because the states have, and this was hard to explain, but they have an interest in encouraging responsible procreation. And we went around and around with them because the interest or ability to procreate has never been a condition of marriage. People that are past the age of procreation, or people who are unable to conceive, or people who have no interest in conceiving, are allowed to get married. People in prison are allowed to get married. People who are on death row are allowed to get married. So procreation is not it. Procreation is certainly part of marriage in many cases. But we pointed out in the case, this isn't the right of the state. This is the right of individuals. If you think of it as the right of the state to advance procreation, even if you could make sense of that argument, it isn't the right of the state. Because if the state had the right to allow people to get married because of procreation, if the state, like China, decided we want to reduce procreation, then the state could take away the right to get married because it would somehow, theoretically, reduce procreation. Some of you know that's not going to work. But the point is, and we kept trying to make the point, this is not the right of the state. If you reverse it, in many countries of the world, the state gives you rights. This Constitution was created by the people that gave limited power to the government. Everything else belonged to the people. The government doesn't have any rights unless we give the rights to the government to restrict, to regulate commerce, or do things like that. But we start with the rights belong to the people. The rights don't belong to the states. And I think that's so fundamental. We tried to make that point in our briefs and every time we talk about this. We're talking about human beings and the rights that we have, and the Declaration of Independence. These are inalienable rights. We are endowed by our Creator with those inalienable rights.
I want to ask both of you about something else that came up before the court. Justice Alito raised another issue that often comes up in these big, groundbreaking cases, and it certainly came up in this case. Alito urged caution. He raised this idea that I'm sure both of you are familiar with, the court, quote unquote, getting ahead of the public. You want us to step in, he said, and render a decision based on the effects of this institution, which is newer than cell phones or the internet, another quote that got a lot of play. He said, we do not have the ability to see the future. What do you think about this? I'll go to you first, Mr. Boies, but I'm guessing you both have lots to say about it.
Sure.
This idea that you two are pushing the court and the country in a direction that perhaps it's not ready to go.
Well, remember, we didn't necessarily push the court to take this case.
They agreed to take it.
True enough. Yes. We were perfectly happy with the Federal Court of Appeals decision. It was in our favor. So if they had wanted to wait a little while before wading into these waters, that would have been fine with us. I think that inevitably the court has to lead. I think the court has always been at its best when it has led, as it did in 1967 when it said to Virginia, no, you cannot put people in jail because they marry somebody of a different race, or when they said in Brown against Board of Education almost 15 years earlier, no, Kansas, you can't tell students to go to school in separate schools just because of their race. Or when the court has said that anybody who is arrested by the police has certain basic rights, and those rights have got to be respected whether you believe they are guilty or whether you believe they're innocent. I think the court has also been at its best when it's recognized the mistakes it's made. I think the court has recognized that cases like the Dred Scott case, in which the court approved slavery, or Plessy v. Ferguson, where it approved segregation, or the Japanese internment cases, where they approved rounding up American citizens who had engaged in no improper act simply because of their ancestry. The court has said in subsequent cases, with respect to each one of those cases, that's wrong. And I think that's a strength of the court. I think the confidence of the court to be able to recognize when it is wrong and when it has failed to lead. The Constitution was designed to make the court lead, because if you only go by the majority rule, you don't need a written constitution of rights. You don't need a Bill of Rights if you're just going to allow the legislature to decide every time, are we going to have freedom of speech, are we going to have freedom of press, are we going to have freedom of religion? Are we going to allow people to be incarcerated without a jury trial? Are we going to allow states to limit who can get married? So every time the court steps in a constitutional case like that, it is stepping in because it has to lead. It has to say, no, the Constitution says something different than what this temporary majority, either in the national legislature or state legislature, believes. So I think that's inherent in our Constitution, certainly since Marbury against Madison, where the Supreme Court recognized that it had to be the final arbiter of the Constitution. The court has been in a position where it is inevitably had to lead. Now, the court never wants to get, maybe from a public relations standpoint, too far out front. It's subject to criticism when it does. But I think it's also subject to criticism when it doesn't. And I think that if you look at the great justices of the court and the great judicial opinions, they are opinions and justices who rose to the occasion and expanded human rights, expanded civil rights, not the ones that curtailed them or held them back.
That's interesting. Mr. Olson?
Well, I can't
Yeah.
answer it better than David, but it came up in the trial court too, the trial court. And the courts raised this question, and I can't read Justice Alito's mind with respect to why that question was raised, but the courts are concerned that people understand that they have to make these decisions sometimes despite the will of the people or a majority vote. And the answer really is, that's your job. Minorities don't win elections. The unpopular people or unpopular people that look different or think differently don't win elections. The majority wins elections, and those are the, you know, we have courts because we don't turn this over to George Gallup. And I basically said in the politest way I could to the trial judge, that's your job. That's why you are there. That's why we have judges. That's why we have an independent judiciary. Because if you just put things up to a vote, unpopular people or unpopular ideas will lose. And it's particularly true in the First Amendment area. People who express unpopular ideas or won't take a loyalty oath or do that sort of thing. The Supreme Court decided just a case a year or so ago about some people that were saying vile things at funeral, and the same people are going to be back in the Supreme Court, I think, next year, but they're saying vile things at funerals of our soldiers. The Supreme Court said, well, you know, we let people say those things because of the First Amendment. But that is an instinct that people have. The first time I told my mother about this case, she said, well, what about the people who voted for Proposition 8 in California? And I explained to her, and she's pretty smart, she picked it up, and she is that, but that's the natural instinct. I mean, are we taking away things of the people? It's very important that people get to vote. But that's why we have three branches of government. That's why we, as David says, we have a constitution, and that is your job. You know, that's why you have life tenure. You get to make unpopular decisions, and they can't take you off that bench.
Do you think people appreciate that, Mr. Boies? The idea that if we didn't have a court system, you know, there is the idea that majority should rule, people win elections, but, you know, he made a compelling case, and so did you, that if we didn't have courts, we would be sort of run by, with all due respect, Mr. Gallup. Do you think people understand / appreciate that?
I think people appreciate it to some extent. I think everybody appreciates it more when you are the object of the discrimination. I think that...
Or when they rule in your favor.
You know, I think that when you have people who are not subject to discrimination or don't think they will be, I think it's easy to be a little complacent and not appreciate the role of the courts. But I think even people who are fortunate and are the least likely to be the subject of discrimination and constitutional violations know that if we're going to have the kind of society that we all want to have, we're going to have to respect the rights of other people and not just our own rights. We're going to have to find a way to work together. We're going to have to find a way in which, even when we disagree, we respect the rights of people to disagree with us under the First Amendment. Even if you are a person who has a sincere religious belief that says marriage and sexual relations should be limited to people of opposite sexes. And a number of people in this country have a sincere religious belief about that. They're entitled to that belief, but they've got to recognize that the First Amendment that guarantees them that right of free exercise also prohibits an establishment of religion and prohibits anyone imposing their religious beliefs on somebody else. And one of the things that happened in Proposition 8 is you had churches on both sides arguing their vision of what their religion taught. And the basic premise of the Constitution is the state's got to stay neutral. The state stays out of the business of deciding which religion, what religious tenets succeed and what don't. So I think that if you think about it, and I think you mentioned civics classes. I think civics classes are terribly important because I think civics classes teach people the importance of the community and the importance of working together and the importance of respecting everybody's rights. And when you do that, you have a better community. You have a more effective community. And I think that one of the things that's happened in this country is that we have gotten away from the ideas and ideals of cooperation, respect for other people. People are very passionate about their point of view, and that's fine, but they can't seem to sit down and talk with and work with people who disagree with them. Our Constitution presupposes cooperation. It presupposes that you're going to have people who disagree, but nevertheless are not disagreeable. We have such divided powers that our system of government can't work if we don't cooperate. The divided powers weren't set up for that way. They were set up to try to prevent the accumulation of powers like a king or a runaway parliament. But the result of that is that if we don't cooperate, we can't make our system of government work. And I think that people who think about that and think about the role of the courts in making that happen will appreciate that. Do enough people appreciate it? No. Is there a tendency only to appreciate it when you need it? Yes. Can we make a difference, though, in things like civics and thinking about it? I think we can.
Well, and speaking of working together with people we often disagree, I would like to turn away from the Constitution for just a minute or two and ask both of you about your own working relationship, your own strong, deep friendship. Much has been made of the fact that you two argued on the opposite ends of Bush v. Gore. Now here you are working on this enormous case. You're tight friends. To you first, I think, Mr. Olson, when did this friendship first start to take hold? And what did you think of Mr. Boies when you were up against him during Bush v. Gore?
It grew, in a sense, out of that. We had known one another. Our backgrounds are somewhat similar. We're pretty close to the same age, and we got in litigation, and I respected David from afar because you read and admire people in your profession who are really good. There's nobody better on the planet than David. And what did I think when I was against him in Bush versus Gore? I watched him. The Bush versus Gore was 5 weeks of pretty intense. It was political storm, and it was a media storm. There was television trucks everywhere. We were required and obligated, because it was a political popularity thing, and we each wanted our messages to be understood by the American people. So David was on television a lot, and so was I, and his colleagues and my colleagues, and his surrogates and our surrogates and people we could drag off the street to put in front of him. Because it was going 24 hours a day. So, and then we were in court. We were writing briefs, and we were on opposite sides in court. David is extraordinarily good at explaining, getting to the heart of what the issues are and then explaining them. So I would find myself watching David explain the points of view. And I had to catch myself because I started nodding my head. So, but that entire relationship, and I don't want to make this too long, but that entire relationship was very professional and very respectful on both sides. We all respected the lawyers and Al Gore and the political team, and it was very important for us to do that. We felt this coming back the same way. After that decision came down, and I had to go through a contentious confirmation process. Since I was appointed by the president to be Solicitor General, and I think some of the Democratic senators were going to make sure that I wasn't going to get rewarded for this despicable decision by then being made Solicitor General and so forth, that David came to my defense, and we, over the years, our families became close together, and we've done things together. We actually agree on a whole lot more than we disagree on, including Cabernet Sauvignon, Bordeaux wine, and bicycling in Europe and things like that. But we have become, we're still on opposite sides of cases. Our case earlier this year, a very intense case in the United States Court of Appeals for the Second Circuit involving billions of dollars. We're on the opposite sides of the case. And again, he was arguing in court, and I was thinking, wait a minute, this sounds awfully good. It can be. But that's in the courtroom, and we do it within the confines of the ethics and the standards, and you respect the other person in the arena. And I found every time I've watched David, I've learned enormously. We've both been practicing law almost 50 years, and that's 50 years each.
That's right. I think they may have known that.
But David's cross-examination of those witnesses, if any people want to be a really great lawyer, you said Clarence Darrow, or you said Clarence Darrow, that's what I was thinking of when he was cross-examining witnesses and causing several witnesses who were going to be listed as witnesses, expert witnesses against us. David took their depositions and sort of dismantled them on video before the trial, and they decided maybe they didn't want to be a witness in the actual trial. And the one that did show up, then David dismantled during the trial. And that was maybe another question at some point. But we can work together because we respect one another, and this is the easiest man I've ever worked with in my life.
And it's not personal. That's the difference. It's just professional when you
Well,
want Bush
it's
v.
both
Gore.
personal and professional, and when we're, our opponent, the lead lawyer against us in Proposition 8 case, is a very fine lawyer and a very decent guy. I think that he's on the wrong side of this issue, obviously, and I think he probably believes the arguments that he's making, but he's a decent person. We started every day in sort of embracing one another and shaking hands so that the people in that courtroom could see that this was a civil experience, a professional experience. It wasn't nasty and wrangling or rancor or anything like that. So I think that's very, very important. But working with David Boies, anybody would want to work with David Boies.
How about you, Mr. Boies? Again, Mr. Olson's described it beautifully, how you always respected each other, came to respect each other more after Bush v. Gore, but maybe it's a little easier for him to be magnanimous since he won that case.
Yeah, I'd say so.
So talk about your own sort of coming together.
On the other
with him.
hand, one of the things I was absolutely clear about after that is I was going to have him on my side next time.
Yeah.
But one of the things that you get to know about somebody when you are against them, particularly in something that's as intense as Bush v. Gore or the Perry case, is you really get to know their character. You get to know their abilities, you get to know who they are, because you see them under all sorts of pressure, and you see them under every circumstance. And that kind of pressure cooker environment tells you a lot about who somebody is, what their character is. And I think that I'd known Ted before, and he had the reputation as sort of being the leading constitutional lawyer in the country. And I admired him to the extent I knew him, but I didn't know him very well. But when I saw him up close, and I saw him in that case, you could not help but admire his ability and his integrity. Lawyers sometimes forget what a powerful weapon integrity is. People sometimes think that by pursuing a short-term shortcut, by dissembling, by obscuring facts, you're going to get an advantage. And you sometimes can in a short-term environment. But it costs you what your most important strength is, in a courtroom, and maybe in life, which is your credibility. And Ted never lost that lodestar. He never looked for the short-term advantage as opposed to making the fundamental point that he needed to make to win. And you have to admire somebody like that, and I did. I also like his taste in wine. He fortunately is about the same speed on a bicycle as I am, so he doesn't show me up in that way like he did in Bush v. Gore. But it's been a wonderful friendship. I mean, Ted is one of my closest friends. I think we are not as much of an odd couple as people make out, in the sense that I think there really are a lot more common ground than some people would think. But there are many, many issues that we disagree on passionately. But that doesn't mean that we can't be friends. It doesn't mean we can't work together on the issues that we agree on. And it doesn't mean that when we're passionately arguing about these issues, we are attacking the other, or we're feeling that the other is attacking us. I've got 6 children. 2 of them on the absolute opposite sides of the political spectrum, far more removed than Ted and I am. When we get together at Thanksgiving, Christmas, and events like that, it doesn't take them long before they are vigorously arguing at a very high decimal level. But they are very close, they love each other, they work together, and they can fight, dispute, argue without becoming disagreeable. And I think that's part of the process of the court system. It's part of the process of our American political system. Lawyers perform a function. We're part of the process. We don't decide cases. We argue cases. We present the evidence. And you need somebody on the other side presenting the other side, because if you don't, the adversarial system doesn't work. The adversarial system only works when you've got 2 competent, careful lawyers with integrity on each side, because that's what brings the questions out. That's what brings the debate out that allows a judge or a jury to make a decision. And so if you respect the process, you inevitably are going to respect people on the other side who do a good job. And when you're in a really complicated case that's going on very intensely, the person on the other side is also about the only person that you can really talk to, because it's the only person that's as obsessed with the case as you are. Your children have long since lost any interest in talking to you. Your spouse will from time to time try to feign a continued interest. But the fact of the matter is that you are so involved in it, the only person that really understands you and that you can really go out and talk with is somebody on the other side. And so it is natural that lawyers would come together, and I think it's one of the shames that's in our profession that over the last few decades, lawyers have become much less respectful and collegial, civil towards each other, and have sort of begun to think that because they're fighting in courtrooms, they've got to fight outside.
Well, and that raises a question, too, about our current political system, and there's so many who say that that quality that you talk about, respect, collegiality, is missing today in our political system. I talk to a lot of politicians, and those of a certain age say, it's gotten bitter, it's not fun anymore. I wonder what you think, Mr. Olson, what example did the 2 of you serve to our leaders in Congress and in state legislatures that, you know, look, you can have your views, but you can also come together and work on issues?
Well, I'll just say a couple of things about that. First place, I don't know how many people are looking at us and deciding that we're the examples or anything like that, but it wouldn't hurt if people listened a little bit to what he just said, you know. But people think it's worse now, probably didn't read the things that were being written about John Adams and Thomas Jefferson in 1800 by Alexander Hamilton and John Marshall and so forth. That was really nasty stuff. So I don't know whether it's worse now or not. Now, I do think that there are some things that are very frustrating, and that it seems like nothing can get done because people are polarized, part of which is in part because we've got a redistricting system that causes safe districts to be created. The Republicans do this and the Democrats do this in equal measure, and they do it for one another. They will, if you get redistricting, maybe it works differently here, but you know, I grew up in California, and it's a big state and lots of districts, but the Republicans will make sure, if they're in control, which has not happened for a long time in California, but it would be nice if it switched a little bit, but they will protect this assemblyman and that state senator's district, so that is overwhelmingly a place where that person can run without opposition or with very little opposition. And so that individual running for Congress only has to favor that side. You're not going to spend a lot of time thinking about the other people's points of view. And we do have, it's very, very contentious. I live in Washington, there is, people do talk about the fact that it used to be more of a civil thing. They keep citing Ronald Reagan and Tip O'Neill, how they were on terribly opposite sides of the political spectrum, and yet they would sort of talk to one another and communicate with one another. They got quite a bit of things done. It may have helped that they were both Irish and liked to tell jokes, and they were pretty good at it, and that sort of thing. I don't know what the answer is to people that feel that way, and I really don't know how you go about measuring it. It is unfortunate to the extent that people aren't willing to listen more. And I think that I went to college out in California, and I spent virtually 4 years on the debate team. I did speeches and debates and so forth. And one of the things about debate is that you were on the affirmative of the proposition at 11 o'clock, and at 1:30 you were on the negative, and then you were on the affirmative and the negative, and it caused you to understand issues on the other side. And I think maybe it might be helpful sometimes for politicians to be forced every week, you know, to write a column just to say, well, if I was really for gun control instead of against it, I would make these arguments, and maybe that would work. But we're not going to be able to get them to do that. I don't think that's going to happen. Maybe you can get them to do it on your show.
Well, at this point, those of you in our audience who are interested in asking a question to Mr. Olson or Mr. Boies, you can start making your way up to the microphones, which are in the aisles, so please make your way. And while people are getting settled with that, I am going to ask you one more question. I have so many, we could go on forever. When we talk about the Constitution, we debate these issues that we've talked about, the 14th Amendment, the 10th Amendment. David Boies mentioned the First Amendment. We often talk about the intent of the founders. What was their intent? What did they really mean? I wonder, I'll start with you, Mr. Boies. If you could sit down for 5 minutes with the founders and ask them, what did you mean by that phrase, by that word, by that sentence? What would you ask them? You've just got 5 minutes. What did you mean by that, founders?
This is probably not a very satisfactory answer to you, but I really don't know that, other than as a matter of sort of curiosity, I would really care what was in their mind, because of two reasons. One is, when you talk about intent, you're not talking about subjective intent. You're not talking about the intent of what was in people's minds, basically. You're talking about the objective intent. What did this mean in the context of the times? So if you're talking about original intent, you're talking about what is the reasonable interpretation of these words in the context of the time. So I think that what is more interesting in terms of trying to find what is the original intent of constitutional provisions, to find out what did people other than the drafter, what was going on in their minds, in their society? What was the normal interpretation of these words and phrases? Because that tells you what the objective interpretation of it is. The second reason why I would have perhaps more limited interest in what was in their mind is that I think that the concepts that are most likely to generate that kind of interest are the concepts that were intended to be elastic, that were intended to be adaptable. We have a Constitution that is extraordinarily hard to amend when there is any significant opposition. When you have amendments in terms of limiting terms to 2 for the president that everybody agrees with, it's easy. It was easy to get prohibition passed. It was easy to get prohibition unpassed.
I like the latter part.
And I agree with that. But it's if you're talking about changing the political balance, or should you eliminate the electoral college? Should the Senate continue to have the powers equal to the House of Representatives? Should you have a divided government the way we do? Or should you have a parliamentary system? Those are issues that are essentially foreclosed, except over an extraordinarily long period of time, by the difficulty of amending the Constitution. As a result, the Constitution needs to be a charter. It needs to be something that sets forth certain basic parameters of dividing legislative, judicial, executive power, certain rights of the people, and then uses concepts like due process, equal protection, right of confrontation, freedom of religion, right to petition for redress of grievances. Concepts that can mean different things in different times. That when you had freedom of the press, nobody was thinking about electronic journalism, nobody was thinking about radio or television or the internet. How do you take the concept of freedom of the press and apply it to technologies that nobody had ever thought about? Everybody agrees you need to do that, I think. But the question of how you do that is part of what makes constitutional law so interesting.
So we shouldn't be so hung up on what their intent was.
Well, there's subjective intent. I do think original intent in the sense of the objective intent of the words they used. I think that is important. I think that's particularly important when you're talking about what it means in terms of dividing power. Because the founders had a concept of separation of powers, which most of our laws today are made by administrative agencies. Nobody thought of administrative agencies at the time the Constitution was being adopted, and if they had, they would have prohibited them.
I think they did, but
exactly. They tried.
They tried. They said,
exactly.
The executive.
The
executive
and separated the power.
Not the Federal Trade Commission.
Right. And so,
what do you think, Ms. Jules? And we've only got one person at the mic, so we do have time to take your questions. Don't be shy. But what do you think about that question, Mr. Olson? Are you not? I'm not saying Mr. Boies is not interested, but I like his response. It doesn't matter quite so much to go back in time and ask them what their intent was.
I can't very much improve, and we're not so far apart on these things. When you listen to the big debate about original intent between the best spokespersons on this debate are Justice Breyer and Justice Scalia, who go around the country having this debate. It's a pretty great debate. But the framers didn't agree. If you could talk to 5 of them, Thomas Jefferson and John Adams did not agree on the power of the central government and whether there should be a national bank and all of those things. They didn't agree on a lot of these things. and David's right, these are subjective phrases. What's a reasonable search and seizure? What's a cruel and unusual punishment? What is what is just compensation? We're having a debate in Washington now, there's 2 court of decisions as to what is a recess of the Senate. So that the president can make an appointment without confirmation during a recess of the Senate. What the heck is a recess of the Senate? In those days, they were gone and you couldn't talk to them and they couldn't, but these days it's totally different. And then this reasonable search and seizure, there's a Supreme Court case just last term about putting a GPS device on a alleged drug dealer's car so they could track him down without a warrant. Or there was a case earlier about a heat device that you could fly over someone's house and see that there was a lot of heat coming out of that. Either there was a lot of hot tub activity or they were growing marijuana, you know. Those lots of things you can't answer by any kind of original intent. And Justice Alito was making fun of Justice Scalia in one of these cases about the GPS device because Justice Scalia was referring to it as a trespass because they put the device on the car, so it was sort of trespassing on the car. And Justice Alito says, now how do you put that in the concept of original intent? You could imagine this small magistrate, this little tiny person magistrate, concealing himself in a giant coach, you know, going. So all these things are fun to talk about, but they don't yield a lot of answers. And I think David's right. It comes right down to, we're talking elastic principles, and what was it meant to prevent the government from going into your home? It was meant to protect your privacy, and now you have to figure out what does that mean in other concepts. So it's important what not just the framers thought, intent, but it's the people who ratified the Constitution. You read the Federalist Papers and the Anti-Federalist Papers and the debates in the state legislatures, New Hampshire, Virginia, and so forth. That sort of tells you what they thought those words meant. So that helps inform the debate too. And it's really good to have these conversations because it's all part of what you were talking about, David's talking about, civic education. What you're all here tonight to talk because you care about the Constitution. I saw the title of this thing, you must be interested in the Constitution. It wouldn't be in this room, which is really good.
Well, let's go to some of our audience members. And if you could address your questions to either Mr. Olson or Mr. Boies or both, and we'll try to get to as many as possible. So go ahead, sir. Why don't you go first? Thank you for being here.
To either or to both, mention was made of Speaker O'Neill and President Reagan. As you spoke, I thought of Senator Alan Simpson on the right, Wyoming, Senator Ted Kennedy on the left. They would debate vigorously on the floor of the Senate, and they would go have lunch together after the vote. I get the sense that's not happening so much now. I get the sense some senators aren't even speaking to each other except in the way of demonizing the other person. More specifically, I'm wondering about filibuster. I think originally there was good intent in having that tool that could be used occasionally. It seems to me it's being much overused, being abused, and I think it's poisoning what used to be a statesman-like U.S. Senate, at least much of the time. So I'm wondering if you have thoughts about the filibuster. Is this going to undo the work of the U.S. Senate for the rest of this term?
That is a great question. Thank you. Why don't you take that, Mr. Boies or Mr. Olson? Either one of you.
Well, I'll say something, and David will too. If you want to hear the opposite point of view, the key to debate, you listen to the Democrats when the Republicans have the Senate, and the Republicans when the Democrats have the Senate. They say the same thing about the filibuster. You know, if you're the minority party, you want the filibuster, and you'll say the exact same words as when the other people did. So I don't think the filibuster ever served much of a purpose. You know, I mean, we have a majority vote, and when you give it that, and the Constitution in 5 places specifies that there's a supermajority requirement to ratify treaties, to propose amendments to the Constitution, to approve ambassadors, or there's 2 or 3 other things like that, where the Constitution says it requires a supermajority. It doesn't say anything else about supermajorities. So the Senate has created this, and the Senate has created it, and I'll get drummed out of the Republican Party for saying this now, but I think the filibuster is an abuse of power because when the majority of the senators want to vote something, they should have the opportunity to vote for it, and you shouldn't deny them the right to vote. What it has done, the reason why you have Republicans and senators supporting the filibuster, it enhances the power of each individual senator. Because when they can put a hold on a nomination, or they can have a small number of people that can prevent a vote, then you enhance the power of each individual senator. So that's a matter of personal power of the individual senators, and they're sort of willing to give up the institutional power of the majority to preserve the power of the minority, which comes down often to the power of one.
Wow. Wonderful question. Thank you so much. And go ahead over to this microphone.
My question may link this big picture with the individual case involved, but I was wondering, we talked a bit about your political differences and similarities and agreements. Was there anything, as you approached this particular case, did you find that you were approaching it from different directions, or was there something about the case that had you approaching it the same way?
You're talking about the Proposition 8 case?
Yeah.
Yes.
Yeah,
Yeah.
go
Yeah,
ahead.
let's
Yeah, I think we approached it almost exactly the same way. I don't know of a single time where we have disagreed with what we would argue, or even really how we would do it. We have a lot of vigorous discussions as we're arriving at our final position, but I don't think we've ever really come at it that differently. And
I was
the
wondering about
fundamental,
that too, yeah.
the fundamental thing is that I think both of us approached it as an issue of civil rights, of constitutional rights, of human rights. And I think that one of the things that we wanted to do in this particular case is we wanted to send a message that this was not a Republican or a Democratic issue. It was not a conservative or liberal issue. It was a civil rights issue, a human rights issue. And when you think of it that way, and you think of it as a constitutional issue, it doesn't make any difference whether you're liberal or conservative, Republican or Democrat. We all have a stake in equal rights. We all have a stake in the Constitution. So I don't really think that we ever really approached it very differently.
No, and I think, one example, I think we both felt that the most powerful thing in the case was when, at the very beginning of the case, we represent two males, a gay couple and a lesbian couple, and we put, those were our first four witnesses. David put the male witnesses on, and I put the female witnesses on, and we just asked them, we didn't prepare them, we just asked them to talk to us in the courtroom, to tell the judge and the people in the courtroom their story, what it's like to be gay in California, what's it like to not be married, the lesbian couple have 4 boys, they were raising their boy, what is it like to go to school and not have a relationship like the other couple in the next place? What would it mean to you if you won this case? And we were overwhelmed with emotion. If you looked at those individuals in the eye and heard them tell their story, you couldn't, at the end of that testimony, deny them the right to get married and to be treated equally. And when I did my closing argument, I said, the judge allowed us to have a video of the trial. It was never made public because the other side did not want the American people to see this trial, which just tells you something about their position. But we were allowed to use the video and the segments of the video in the closing argument. And I said to the judge, I can't make a more powerful closing argument than the words of these individuals. And we played little clips of their testimony. That was an area where David, of all the areas, and David's absolutely right, there's never been that much space between us on any issue of style, tactics, anything. But that's one of the example of what we felt about the case was about people, about individuals and human beings. And that's an example of how we approach the case.
Yeah. Well, thank you for the questions. One I had too, whether you approach this differently. So thank you for that. And let's go back to this side of the room. Good evening. Thanks for being here. Go ahead.
Hi. Sorry, I'm blind, so I have to find the microphone. My name's Tim Young. I'm not a law student or a lawyer, or I'm just more of a person that's mindful of the Constitution and my rights, especially as a disabled American, but also having had a person that's been in my life for 18 years, and living in New Hampshire now, in a state that does recognize gay marriage, and the whole northeastern border. borders. You know, you look at the northeastern map, and the Northeast is what is really taking hold of this and saying we need to recognize this among all the other states. There are some that are scattered within the U.S., of course, but my comment is one before my question. I'm sorry to take up so much time, but I come from a Christian family, and so it's a point of contention sometimes with my family, but I am a gay Christian, so that's also, you know, something that is probably something of a wonder of the natural world. Gay, Christian, and blind, like, either God really loved me or really hated me. But my comment, or my question is to you, how did your colleagues receive you, both coming from different sides? How did your colleagues receive you? Especially, I think it'd be more so pointed to you. I'm not sure how to ask the question. Is it Justice or Sir or Mr.?
Oh,
Olson.
Mr. Yeah, or
Olson.
just
Mr.
Ted.
Olson.
Mr. Boies, yeah.
Mr. Olson. I'm not sure, because I don't have a program I can read. It's not in Braille, so my question would be to you, especially, but both of you, of course, could answer. How you were received, because I would assume that your views are more conservative, more Republican. Am I wrong in that? I don't know.
You're close.
Okay. Well, then I'll leave it to you to answer those questions and how your colleagues received you and how the support has been among your colleagues, because I'm sure it's a back and forth. Or
Right, sure.
It's a great question.
I
I'm sure
get
one
that.
you've gotten. Yeah.
I get that question a lot. There are some people, well, first place, let me say that, as David said it already, we believe this is not a conservative or liberal issue or a Republican or conservative issue. And we don't believe that it should be thought of in that way yet, but you're correct, it is. Though David Cameron, the conservative Prime Minister of England, said he was in favor of gay marriage, not despite the fact that he was a conservative, but because he was a conservative. So if we conservatives believe in equality and dignity and privacy and keeping the government out of our lives unnecessarily, limited government and those sorts of things, we theoretically, if you want to go along with the stereotypes, the conservatives believe in family and stability, and you want to make a commitment to another person that you love to live together and share responsibilities and support one another. What could be more conservative than that? I wrote a long piece that was a front page thing in Newsweek magazine called "The Conservative Case for Gay Marriage," because I felt important to explain it to conservatives why they should be on the same side on this. But to answer your question, there are some conservatives aren't monolithic either, because there are value conservatives, so-called, and there's libertarian conservatives. The libertarian people are very supportive. The Cato Institute, which is a premier libertarian institution, think tank, is all for us. But there are some people politically who feel that I've betrayed my principles and are very, very angry about it, and there's been, a palpable level of hostility from some quarters. But I hasten to say that in the first place, that goes with the territory. If you're going to take a position, you'd better be willing not to give back walk away from that position because some people won't like it. What kind of a lawyer would we be, or what kind of a human being would we be? But I'm overwhelmed by the reaction of most people. And you heard it in this room at your applause of the fact that we're doing this case together. Overwhelmingly, people are saying, and includes my colleagues in my law firm, saying, it's great that you're doing this, and thank you for doing it, or thank you for standing up for us.
Yes, thank you.
Okay, thank you.
Thank you for doing it. These are wonderful, wonderful questions. Thank you so much for coming up to the microphone. Go ahead, sir, and thank you for waiting.
Thank you. My question is regarding something Attorney Boies said that surprised me. You mentioned that you would have been happy had the Supreme Court not taken this case. It seemed, from an outsider's perspective, that this was a case set up to go to the Supreme Court from day one. And obviously, there's still the chance that the Supreme Court will issue its ruling based on standing rather than reaching the merits. If they do that, how will you, and this question is for both of you, how will you view this case, how successful it's been, and would either of you get involved in another case to raise the issue again?
Thank you. Mr. Boies, why don't you go first on that? Yeah.
This is a case that's going to be decided by the Supreme Court eventually. I think that no one doubts that there's going to have to be a single authoritative decision on this issue, and that can only come from the Supreme Court. The question is when, and the question is how much progress do you make before then. I think that we would all love to see, by all I mean those of us who are on the side, the Supreme Court decide the case our way on the broadest possible grounds in June when we expect to get a decision. On the other hand, if we win on any ground, including the ground that the Supreme Court didn't take the case, or the Supreme Court dismisses the case now on the grounds that they decide that they shouldn't have taken it in the first place, which at least two justices during the argument sort of suggested they might do, then our clients get married. And everybody in California who wants to get married can get married. And that's about a sixth of the population of the United States. It's more than a tenth. You've got the states in the Northeast that were mentioned. You've got New York. You have now a critical mass of places where you have marriage equality. And so I think that you always would like to have a complete victory. But I think you'd have a very substantial victory if you can simply make sure that everybody in California can marry the person that they love. And so I would have been perfectly happy to have my clients married by now. If they hadn't taken cert, they and tens of thousands of other citizens in California would now be able to get married. You would have had people whose lives are running out. We've had people come up to us who have been together for 20, 30, 40 years, and they haven't been able to get married. They want to get married before they die. I would have been happy to see that happen.
And we did, when we were came together to bring this case, we prepared it, you're absolutely right, for the United States Supreme Court. We wanted to make sure that we had the right plaintiffs, that we brought it in the right case, that we had the right resources, that we could use, we brought expert witnesses from all over the world, people, experts in psychology, in history, in discrimination, the damage done by discrimination and parenting, and all of those things. So we spent an enormous amount of time building a foundation for this case to be in the Supreme Court. But, as David says, we're representing human beings, and we set out to overturn Proposition 8. We also set out, and so any victory overturns Proposition 8, whether it's standing or anything else. We have a decision from a district court where the defendant was the state of California and an injunction against the state of California prohibiting the enforcement of Proposition 8. And so that's that if we win. So we've won if we win that. We don't take anything for granted. We've never taken anything for granted. We would like to have the whole thing changed. And we've really set out not just to win the case and not just to win Proposition 8, but we also set out to change, to the extent that we could contribute, to change the attitudes in the United States and hopefully the world about this issue and discrimination. So we had an affirmative goal. We've worked very hard on this, maybe just as much as the legal part of it, to participate in the dialogue that would persuade the American people that this is the right place to be, because we wanted, if we won the case, we wanted the American people to say, of course, that's the right result. And the polls have changed, and we're not saying that it's attributable to us or any part of it attributable to us, but when we started this case 4 years ago, this month, the polls showed a differential of 17% against, the difference between plus for and against marriage equality was 17% on the negative. It's now something like 15% on the plus side. So we're talking almost a 30% change in public opinion in the United States. There were more polls just this week that show that that attitude has changed. There were 2 states that allowed marriage equality when we started, at 13 as of Minnesota just this weekend or just this week. So, and I think lots of things have contributed to that, but we've saw this case in a holistic manner, that we're representing people. We want to win the case, but we want to win it, if it's necessary, on a short-term basis or an intermediate term and long-term basis. And at the end of the day, to the last part of your question, what do you think, we think that we will have accomplished at the end of the day? Time magazine had it on its cover. It's over. Yeah. They may not be right. Time magazine has been wrong before. Not when they put David and me on that list. But it is very important. This very thing that we're doing tonight is important, because the more we talk about this issue, the more people are willing to understand. I think that dignity and equality and decency and the American values bring us to the same point.
Oh, and I would love to go on all night. I'd like to take just maybe 1 or 2 more questions, and maybe we'll direct them to just one of you so that we can get more folks in. And someone's been waiting at this mic for a while, and you've been waiting at that mic for a while, and then that might have to be it. I'm so sorry.
Thank you. First of all, I have to say, Laura, I admire your work that you do for us every day, and with the exchange and your mind, knowing what our questions are, and always bringing those to the people that you bring in. It's a wonderful, wonderful gift. Thank you. Thank you. And I'm just going to get off. The question's more toward your professional lives. I work in a K-12 school district, so I'm with young people all the time. We talk about what the impression of the Republicans, Democrats, the fighting, the back and forth, the big money that's all behind it, lawyers, you know, how all the generalizations about lawyers and so forth. Looking at your past history, your lives growing up in your law firms and so forth, you've been involved with all different kinds of cases, and perhaps I wouldn't necessarily like what sides you were on in different things. But Mr. Boies, you talked about that, you said the word integrity. About through it all, no matter what you're doing, it's this integrity that is the most powerful tool. That's what young people need to hear, but more and more though, that's what raises up. What do you say to young people who are so really just see everything, money, power, lawyers, and so forth? What do you say to the young people that really want to listen?
And that integrity isn't as exciting as some of the things they see in media and so forth.
It's not, like you said, it's a short-term stuff is what it's all about. Integrity is, yes.
Right, great question, thank you.
I think one of the challenges, I have 6 children and 8 grandchildren, and one of the challenges of young people is getting them to take a longer view. The cheap shot, the dissembling, the cutting the corner has a lot of attraction if all you're interested in is winning a particular point, particular moment, sometimes a particular news cycle. But the people who have the staying power and the ideas that have the staying power, I think are the people and ideas that have integrity. And I don't think there's an easy way to explain that. I don't think there's a simple way to convey to young people or to anybody the power of integrity. I think you have to live it, you have to show by example, you have to talk to them about it, you have to point out the problems that come from taking a short-term view of things. But in the long run, it is a constant struggle. You are always trying to convey that. You're always trying to teach. I think as you get older, and particularly if you're in a line of work that requires communication, particularly communication with very skeptical audiences like judges and juries, you begin to understand the power of integrity. You begin to understand what a weapon integrity can be because of its persuasive power. But it's hard to convey that, and it's particularly hard to convey that to young people. I think that's why civics is so important. I think civics helps teach that. It helps teach the relationship of people to a community, which is probably a good working definition of integrity.
Gentleman's been waiting over here for a while. Go ahead. Thank you for.
Thank you. My question goes back to Bush v. Gore, but it's a little bit broader question, but I'm going to use that as an example. A lot of people following Bush v. Gore would have said that no matter how good your argument was, Mr. Boies, you weren't going to win because 5 of the judges liked Bush and 4 of them liked Gore. And I think that's a dangerous thing. I happen not to believe that, but the question is more, are judges purely politically motivated, or are they jurists who are safeguarding with integrity our charter?
I mean, I think the obvious answer is both. I think that judges are human. Judges are inevitably affected by the same things that affect everybody. They're political in some sense. But almost all judges, at every level, and particularly the judges on the Supreme Court, are people who are devoting their lives to public service. Each one believes intensely that what he or she is doing is the right thing for the country. That doesn't mean it's the right thing for the country. But it means that they believe it's the right thing for the country, which is the first step, in integrity. I think in many ways the courts epitomize integrity because they are people who are devoting themselves to trying to get it right as they see it. I think part of the problem is that they don't always see it the right way. But it's awfully hard to figure out who gets to decide what the right way is. One of the things that both Ted and I spoke to during Bush v. Gore was what's going to happen after this election. And we both said what's going to happen is we're all going to unite behind whoever wins, because that person's going to be president of all of the people. And I think the process by which the Supreme Court makes a decision is the process of the rule of law. And you can disagree with that particular decision, but I don't know of a better way to make those kind of decisions. After Bush v. Gore, one of the interviews that I had was with somebody from Russian television. And he said, explain to me this case. He said, it's hard for me to explain to the people in my country how the Supreme Court got involved in this election. And I said, well, it's sometimes hard for me to explain to people in my country too. We have a system of the rule of law where these kind of decisions ultimately are decided in the courts. And he said, well, that doesn't make any sense. Where is your Yeltsin? Where was the person who's going to stand on the tank and defy this terrible decision? And I said, well, you have to understand that we've got a very long, stable democracy. We know that there's going to be another election. And we know that the result in that election is not going to be determined by the result in this election. It's not a case where one person, one vote, one time. It is a question of having confidence in the stability of our political processes so that even if somebody gets elected that you don't like, you can support them and you can support the process by which that election is legitimatized. And I think that confidence in our court system, that confidence in our democracy, is critical to the stability of our democracy. I think the stability of our democracy helps give us that confidence, but I think that confidence is also critical to the stability of our democracy. And one of the things that Ted and I probably always disagree about is Bush v. Gore. But I think one thing that we always agree on is there had to be a decision. And once that decision was made, that ended the election. That decided the case. And everybody had an obligation to accept that, move on, and unite behind whoever happened to be elected president in that case.
Well, and I see Sherry Young at the podium, and I know this is so hard for me because I'm on the radio, and so normally I don't see the people who don't get on the air, and it's breaking my heart, but we don't have time to get to you, sir, or you second in line there. You have been standing there for an awfully long time. If you could make it just one sentence, we would really appreciate it.
Laura, maybe I can help you wrap this up.
That would be great.
I will forego my question and don't ask for a response. I simply want to say thank you. Thank you for taking on this case. Thank you for lending your incredible integrity and knowledge and experience. Thank you for allowing us to see that people who have different views on some things can come together on something that's important. And thank you for being here tonight to tell us all about what you've done. Thank you.
Thank you. Are you sure you didn't plan that?
I was going to say thank you, but I think the thank you is done. I couldn't have said it better. First of all, I want to say special thanks to all of our sponsors and funders who are listed in the program, and I'm not going to go through them all, but thank you very much for making this possible. I also would ask that anyone in the audience that has participated in all three events, if you could please stand and be recognized. Anybody? Yeah. Finally, one other piece of housekeeping. All educators that are here tonight that are seeking continuing education credits should see Kathy Mathis at a table in the lobby to get certificates of attendance. And with that, I'd love to have a warm round of applause for our wonderful speakers and the questions from the audience. Thank you.